Good afternoon. Happy Saturday. I got a bit of a long one for you today. This is United States versus Chauncey Hollingberry. We are definitely not at a judgment yet in it, but there was another motion for change of counsel filed by Chauncey, and so I wanted to go over it. But I figured I would kind of catch everybody up as to where we are, what the procedural history of the case is, where we are currently, etc. So my understanding is that Chauncey was arrested by a county sheriff or something along those lines for harassment or stalking or something similar to it. And while he was in jail awaiting trial on his state charges, the federal government decided that they really wanted to play ball with him under federal cyber stalking. Now, the fun thing about that particular law is that the people don't actually have to be in different states. If you're using the means of interstate communication, which would be interstate commerce, i.e., a computer and email, then Lord have mercy, you too might be committing a federal crime, not just a state crime if you're harassing someone. So, something to be aware of. The interstate commerce clause has been abused so badly. So, what happened? Well, on the 16th, Chauncey went in front of the judge for his initial appearance, and the judge assigned him an attorney, a public defender. And the public defender's name was Zach Kane. The judge wasn't messing around. The judge asked, "So, Mr. Hollingberry, do you have the money to hire an attorney?" Chauncey said, "Nope." Court said, "Well, I find you qualify for court-appointed counsel, and I appoint Mr. Kane in the Federal Public Defender's Office to represent you for free in this matter." Now, Chauncey didn't object at any point, so I'm assuming he was okay with Zach Kane at this point. Now, next, what happened? Well, if you didn't know, COVID happened. And COVID got all of these motions to suspend speedy trial clock and extend time to indict, and they all kept getting granted because COVID. Next big thing is somewhere around here, somewhere in, it looks like July, there was a motion, and I don't know exactly what that motion was called, but it was going to be motion 38. And in motion 38, Chauncey wanted new attorneys. And this is entry 44. It says this is the minute entry for proceedings held before Magistrate Judge Deborah M. Fine. Motion hearing regarding 38. Motion to determine counsel as to Chauncey Hollingberry. Now, a motion to determine counsel is not a motion for a new attorney. So that just made me consider this. A motion to determine counsel is if somebody thinks that there may be a conflict, and so they put it in front of the judge to determine if the judge thinks there's a conflict with counsel. So I'm wondering who actually filed it. So it's a motion to determine counsel as to Chauncey Hollingberry, held on 8/6/2020. The court finds the defendant consents to proceed with this hearing by telephone after consultation with counsel. Government exits the proceedings. Ex parte discussion is held under seal with defendant and defense counsel. The government rejoins the proceedings. It is ordered that the defendant be appointed new counsel. And then CJA attorney James Paul Busing is appointed for defendant for all further proceedings. A CJA is like a contractor. It's like a contractor public defender. They have a contract with the Justice Department. And if there is a conflict with the public defender's office, like, for example, if the public defender's office is defending one defendant and that one defendant is going to have to throw the other defendant under the bus, then one would probably have the public defender and the other might get the CJA. That way, each counsel can defend their client to the best of their ability, and neither would have to tell one client, like An attorney can't have two clients and be like, okay, client one, for you, I'm going to plead that client two did all the bad stuff. And client two, for you, I'm going to plead not guilty. It just doesn't work that way. There's a conflict there. And that's where CJAs come in typically, or if the public defender can't take it for whatever reason. So this guy's a freelancer. He probably has his own practice on the side. He probably does criminal defense work all the time, and he picks these up for the federal government when needed. So that was the first time this issue has been brought up before the court, and then the next time it was brought up before the court was the 19th of October. Now, the 20th of October is when the indictment came down. So I thought it was interesting that looks like they had a joint motion. So maybe Chauncey Hollingberry did not like his attorney agreeing to a joint motion to extend time. But anyway, on the 19th, we get this humdinger from Chauncey Hollingberry. I talked about the tyranny of the clerk. This bullcrap right here, that's just clerk tyranny. I talked about that in my Bark and Well Parkin back in October, like October 22nd, if you want to listen to it. But that's not really relevant here. So here he has plaintiffs, United States of America plaintiffs. That's pretty cool. So for his motion for change of counsel, what we're looking for is why Chauncey thinks he should get a new defense attorney, what defect he thinks his defense attorney has. And it could be something like he thinks that his defense attorney is biased against him. You know, my defense attorney has my defense attorney has a phobia of Gollum. And so he thinks I look too much like Gollum, and he's deathly afraid of me, and I don't think he can adequately represent me if he's too scared to even look in my direction. You know, that kind of stuff. Something that is actually directed towards the defense attorney. What defect does the defense attorney have? That's what we're looking for. Now comes Chauncey Hollingberry, defendant, for a motion for change of counsel. The defendant submits the following ground for removal and appointment of new counsel. So he's not looking to represent himself. He wants a new attorney. Okay. 1, lack of communication. There's no 2, so I don't know why I put 1 there. Lack of communication. Paul Busing. Paul Busing? James Paul Busing? Jesus, Chauncey. Paul Busing, counsel for the defendant, has refused. Is it Paul Busing? It is Paul Busing. James Paul Busing. James Busing. God. Chauncey. Paul Busing, counsel for defendant, has refused and or neglected to speak with defendant for 30 days. So this is on 10/19. He probably mailed it a little earlier because it did come in the mail. So he probably didn't talk to his counsel since the outcome of the order granting the joint motion for an extension. The defendant will no longer communicate or attempt to speak with his counsel. The defendant, having made the court aware of the circumstances of ground, prays to the court for relief. Now, if he'd stopped there, this wouldn't be bad. It's not good. Did he misspell his own last name? He misspelled his own last name. He misspelled his own last name. Hollingberey. He misspelled his own last name. Holy. Wow. Oh, Lord. Lord have mercy. Besides misspelling his own last name, this wouldn't be too bad for a pro se litigant. Wouldn't be too bad. Or pro se defendant, I should say. The whole plaintiff thing kind of throws me off. He's actually a defendant. So what we're looking for again is bad things that is that James Busing has done. And if he just said, James Busing has refused to speak with me for 30 days, despite my repeated attempts, I have tried to contact him X number of times in Y number of ways, and I have received no communications back. I believe it was urgent. I expressed it was urgent for X, Y, and Z reasons, and I have received no communications. It's my belief that that Mr. Busing is avoiding me and is not willing to take up my defense wholeheartedly for whatever reason, right? Then and you stop there. But then to say I will no longer communicate or attempt to speak with my attorney, I mean that's something you can control. That's something the court is less likely to grant relief on, especially since the court has already granted relief once and given you new counsel once. So Section 1, factual background. Again, there is no Section 2, so I don't know why there's a Section 1. I have redacted the name of victim K. Defendant is charged with one count of cyberstalking pursuant to 18 U.S.C. 2261A2. That is correct. It's not bad to start with the background of the case. Lisa Jennis, I wonder if you got her name right. Is it Lisa Jennis? Lisa Jennis. Yeah, you got it right. I wonder if he served it correctly. Paul Butis. Jesus. So Lisa Jennis, the prosecutor, continues to provide a false and misleading characterization of the facts of the case in a calculated character assassination campaign against the defendant. That has absolutely nothing to do with his defense attorney. In addition, Jennis already did the probable cause hearing. The judge accepted her version of the facts, at least as far as probable cause are concerned. Not only are you trying to muddy the waters with Jennis, who is not relevant to this motion, but you're also basically telling the judge that the judge is stupid. Not a good way to start there. On March 13, 2020, the charging FBI agent and the assistant Maricopa County assistant attorney threatened the defendant with state and federal prison time. It's not a legally cognizable threat if a cop and a DA say, we're going to give you 30 years if you don't do a plea bargain. That's not a threat. That's not a legally cognizable threat. You might feel threatened. You might want to pony up with your best sovereign citizen. I'm taking this under duress, but it's not a threat. The nature of the threat, and there's a period, right? I'm guessing. I don't know exactly what's going on here. The nature of the threat originated from the defendant's claim Charles Cook mistreated his mother and subjected the defendant to various clever forms of child abuse. So Charles Cook is appearing. There's this weird love-hate relationship between Chauncey and Charles Cook, and it's all one-sided. Apparently, Charles Cook wants nothing to do with Chauncey, but Chauncey can't get Charles Cook out of his head. But that I have no idea why he's saying the nature of the threat originated. Maybe they were threatening him to shut up about Charles Cook. I don't know. That's weird. It doesn't make any sense to me. This sounds like Chauncey has got a few too many screws loose, because it really doesn't make any sense. The agent and the assistant attorney stated on the interrogation tape to the defendant to keep quiet or we will keep locking you in prison. Again, that doesn't make sense, because an interrogation, the sole purpose of an interrogation is to get a defendant to talk. I mean, that's literally the point. So why would you tell the defendant to keep up or to keep quiet in an interrogation? That doesn't make sense. The defendant, and again, none of this has anything to do with the defense attorney, Mr. Busing. It's Busing? God, now he has me questioning it. Busing, yeah. The defendant refused, and the agent is heard saying, "Guess what? You are not getting out. Guess what? You are not getting out. I just hit the button to charge you with something else." And then it's the name of victim K. It's not Merbeast. It's the name of victim K. "Guess what? You're not getting out. I just hit the button to charge you with something else, victim K." Victim K sounds like the subject of the sentence. I'm not an English teacher, but it sounds like victim K is the subject of this rather awkward sentence. "Guess what, victim K? You're not getting out. I just hit the button to charge you with something else, victim K." I don't know what he's trying to say there, but I don't think it says what he think it says, and I don't know where he's going there. But again, nothing to do with his defense attorney. The prosecution is aware of the allegations against Charles Cook, but has omitted it from the record. Well, again, its relevance is the issue, and I guess technically, if you're being charged with cyber stalking Charles Cook, maybe you can get child abuse into the sentencing. There's a lot looser evidentiary rules on introducing stuff in sentencing, but I'm not entirely sure you could. But again, it has nothing to do with this case or anything that Chauncey has done. The prosecutor, agent, and assistant attorney are engaged in a conspiracy to protect Charles Cook, the founder of Hope Refuge, a 501c3 nonprofit. Again, he's just in love with Charles Cook. It's really weird. So that was the 1019 motion for new counsel. I did my Barkin will Parkin on 1022 where I addressed it. And then on 1027, they had a minute entry for proceedings held before Magistrate Judge Deborah M. Fine. Motion regarding 48 motion to appoint counsel as Chauncey Hollingberry held on 10/27/2020. The court finds the defendant consents to proceed with this hearing by video teleconference after consultation with counsel. Ex parte discussion held out of the presence of government. Back on the record with all parties present. Defendant having withdrawn the motion, it is ordered denying as to moot. So Chauncey withdrew. Now, the judge probably said something to Chauncey that didn't make it in here. And that thing probably was either we're going to delay your trial if you get a new judge, or you're going to have to do your trial on your own if you fire this guy. So it was probably one of those two things, just guessing. But it took a grand total of 10 minutes for his attorney to convince him once they got off the record that it would be in the best interest to they keep the attorney. And then the trial was set for December 1st, 2020, which, as you are aware, has passed. And no, it did not come to fruition. And it didn't come to fruition because Chauncey's attorney filed a motion to continue, and that motion to continue was granted. Now, why did Chauncey's attorney file a motion to continue? Well, he requested 60 days because he said he needed time to review discovery that's been disclosed, review it with defendant, investigate the case, prepare for trial, and render effective assistance of counsel to the defendant. Now, this was filed on 11/18. It was filed about half a month after, but he'd only been given about a month to prepare for trial. And, that's not necessarily a long time, especially if you're a fairly busy attorney and you have other clients and other things going on. And it can take, a week or so, like a full week to prepare for trial for a fairly small case with very few witnesses. This one, we're going to have at least 6 witnesses. I think there were 6 witness letters. Yeah, 6 victim letters. So there's a lot to go through. There's lots of videos to watch. There are 2 YouTube videos that were included in the probable cause hearing. There are probably more out there that the defense is given over to, or the prosecution's given over to the defense. There's a lot to watch, to break down. I mean, there's going to be some solid man hours in this. And I would bet that you could get at least 2 solid weeks. Nothing else, just going over the case file, watching the videos, frame by frame, sometimes depending on what you're looking for. Just over and over again, just trying to figure out exactly what was said, etc. And I have had very few times where I've had to communicate with defendants in prison, or jail, I should say. I've thankfully, never had to visit anybody in jail yet. But the few times that I've gone to jail, it's a long and involved process to get in. You get in, you got to wait for them to bring your client up, and then you've got a piece of glass between you, and it's just hard to deal with. So it's not, well, I guess technically it's not glass, maybe it's plexiglass, but anyway, it's just hard to deal with. And it does complicate matters considerably. So I can see why he would want that. I can see why he would want that motion to continue. Now, Chauncey didn't seem to take it very, very kindly. And so Chauncey then filed this on December 7th. This is Chauncey's motion for change of counsel. Now comes Chauncey Hollingberry, defendant, for a motion for change of counsel. The defendant submits the following preamble to the court prior to listing grounds for change of counsel. Now, again, I just want to remind everybody, plaintiff, God damn it. I just want to, at least he spelled his name right here. Did he spell his name right? Berry, 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 Berey. Is that not an E? Maybe it's an R. It's not like that R. It's not like that R. I guess it's not like that E. It's not like that E. I don't know. Okay. I'll give him the benefit of the doubt. Now comes Chauncey Hollingberry, defendant, for a motion for change of counsel. The defendant submits the following preamble to the court prior to listing the grounds for change of counsel. So again, what we're looking for is, what did defense counsel do wrong? Why won't defense counsel work? Why won't he work for defendant? So now there's a preamble. Okay, your preamble is 1, the prosecutor, 2, victim K, 3, COVID-19/health. That's not a preamble. That's a list. And none of those things are like the other. CoreCivic is refusing to provide defendant with access to the law library in violation of Lewis v. Casey. Lewis v. Casey does not guarantee you access to the law library. Lewis v. Casey was a group of 22 inmates who all wanted access to the law library. They weren't getting access to the law library, and they didn't show actual harm. The court kicked it back, saying you actually have to show actual harm. You have to show that without this access to the law library or to counsel or to other meaningful access to the courts, that you have some unredressed kind of grievance. And you can see it in this particular section. The foregoing analysis would not be pertinent here if, as respondents seem to assume, the right at issue, the right to which the actual or threatened harm must pertained, were the right to a law library or to legal assistance. So the foregoing analysis would not be pertinent here if the right to a law library, if there were a right to a law library. So the court is saying there is not a right to a law library. But Bounds established no such right any more than Estelle established a right to a prison hospital. The right that Bounds acknowledged was the already well-established right of access to the courts. In the cases to which Bounds traces roots, we have protected that right by prohibiting state prison officials from actively interfering with inmates' attempts to prepare legal documents or file them, and by requiring state courts to waive filing fees or transcription fees for indigent inmates. Bounds focused on the same entitlement of access to the courts. Although it affirmed a court order requiring North Carolina to make law library facilities available to inmates, it stressed that it was merely one constitutionally acceptable method of providing meaningful access to the courts, and that our decision here does not foreclose alternative means to achieve that goal. In other words, prison law libraries and legal assistance programs are not ends in themselves, but only the means for ensuring reasonably adequate opportunity to present claimed violations of fundamental constitutional rights to the courts. Now, what is this dealing with? What is bounds? What is the underlying case dealing with? The underlying case is dealing with prisoners, inmates having access to the courts to seek redress of grievances, saying, my Eighth Amendment has been abused because they're beating me. They're putting me in solitary confinement in violation of my Eighth Amendment. It is guaranteeing access to the courts. If you don't have a law library, you don't know what kind of things you can sue over. If you don't have access to legal assistance, you don't know how to draft a complaint. If you don't have access to legal assistance, you don't know where to mail your complaint with the proper documentation so that you can file pro se your complaint against the prison seeking redress from the courts. It is not about a criminal matter. It's not about a criminal matter. Chauncey already has access to the court. It's access he doesn't want. He's been drugged in front of the court as a defendant. And he has an attorney. His attorney can prepare his defenses. That's the point of his attorney. It's paralegals. CoreCivic has been neglecting to fix the law library computer for a period of approximately 30 days, but you have an attorney, Chauncey. Lisa Jennis, prosecutor, is providing the court with inaccurate information regarding the facts of the case. Okay, nothing to do with your attorney. Victim K, Jamie Morano, Mark Schoenberger, Lauren Reimer, and Charles Cook are not victims, but in fact, internet trolls. That looks like fucked. That's a U. That's an A? Huh. Maybe a little Freudian slip. But are in fact internet trolls, internet terrorists. They are known as Merbites and are soldiers of the army of Merb. Soldiers in the army of Merb. A self-proclaimed OG internet troll. Well, a couple things. Number one is... Reamer has an injunction, Cook has an injunction, and Victim K has an injunction. So at least three of the people, Reamer, Cook, and Victim K, these three, those two maybe no, but these three want nothing to do with Hollingberry. Nothing to do. They've in fact gone out of their way as legally far as they possibly can to distance themselves from Chauncey Hollingberry. And as far as me being a self-proclaimed internet troll, no. That was given to me by Ida Foxy Queen. She's the one who stated that I am an OG troll and I've been around forever. So thank you, Ida Foxy Queen. You are indeed the gift that keeps on giving. And also, I disavow anything called Merbites or Army of Merb. No such thing exists, and if it does exist, I have no part of it. Those individuals have been documented to have been harassing defendant for several years. Okay, well, at least three of them have restraining orders against you, so I don't think they're the ones harassing you. Victim K is an internet terrorist and a corrupt government employee. You know, it's funny. It's funny. The guy's accused of cyber stalking, and just so you're aware of what cyber stalking is, it is you can cyber stalk with the intent to kill, injure, harass, intimidate, or place under surveillance with the intent to kill, injure, harass, or intimidate another person, use the mail, interactive computer service, or electronic communication service, or electronic communication system of interstate commerce, blah, 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 where you place that person in reasonable fear of death or serious bodily injury to a person, pet, service animal, emotional support animal, or a horse, or causes or attempts to cause or reasonably expected to cause substantial emotional distress to a person described in clause 1, 2, or 3 of A1. That's the person, an immediate family member, spouse, or intimate partner. So it's just interesting to me that the guy who's accused of cyber stalking is now accusing the victim of being an internet terrorist, and as though that were a bad thing. And it just makes me wonder. It just makes me wonder psychologically what's really going on there. I mean, I'm not a psychologist, but things just seem so off. I mean, beyond the guy doing the chain thing and communicating with Beelzebub or whatever to figure out if he has a bigger penis than me. I mean, that was weird, but I thought it was kind of funny. I mean, okay, maybe he's doing it for a joke. I'm not entirely sure that the dude was joking at this point. And it gets worse. I haven't gone through this yet, but it gets worse. In fact, I should go through that now because it becomes important for this part. But anyway, just think about that. Think about the guy who is currently indicted for cyber stalking is accusing his victim of being an internet terrorist. But anyway, I haven't gone through this. This is from the probable cause hearing, and I've already said that there were the injunctions. There's 6 victim letters. I think one of the victim letters is from somebody's mom. So there's 5 victims, I guess, and 1 from a mom. Emails from the defendant, not a big deal. The mask is not a big deal. It's one of those V for Vendetta masks. He wore that one to a school. A sign, it said fuck the police. It was found in his closet. The judge said that's clearly protected speech, so the judge didn't consider that. Videos from his YouTube channel. If you ever wonder why the government doesn't have to infiltrate the First Amendment auditor community, it's because you dipwits just post all your crimes online for the whole world to see. But then these are the interesting one, the photographs of the defendant's mother's bedroom. And the interesting things about these is that when Chauncey was arrested, he had 2 credit cards and a debit card, I believe, in his mother's name in his wallet. And the police asked him if he had power of attorney for his mom, and he said no, he did not. But it turns out that, in fact, he did have power of attorney over his mom's finances. So that's weird. Why would he lie about it? I don't know. It's just weird. But anyway, the living situation. So he works at Home Depot, so he doesn't make a lot of money, or he worked, past tense, at Home Depot. Didn't make a lot of money. Allegedly, he worked at Home Depot, I should say. He claims he was. And allegedly, he was going to school to be a paralegal. He hadn't actually graduated from any school yet. That's according to the AUSA. But he had 2-bedroom apartment. He had the master bedroom. I don't know if any of you remember how well appointed the master bedroom was. He had, it looked like the devil's bedchamber in there. And anyway, his mother had the other room, and all she had to sleep on was a beanbag chair. Now, his mother also said that she liked to hike and do other outdoor activities, and that Chauncey wouldn't let her out of his sight. He wouldn't let her out. But he did give her a treadmill. The court didn't take any of that into account. Now, that doesn't mean that isn't information that might have actually made its way into any ruling that the court made on the detention hearing, because the probable cause and detention hearing were rolled up into one. I can only imagine that the court is aware that a 59-year-old woman who has a trust and who has her son with power of attorney over her finances, because she does have a trust, and her son does have power of attorney over her finances, is probably not the most psychologically capable person, especially if her son can keep her inside and not let her out. You understand what I'm saying? Like she's probably not the most sound person of mind. 59 isn't that old, but I mean, there's some warning signs. But then the court went on to say, well, I'm not going to take that into account because, beanbag chairs are comfortable. But again, you know that there's something wrong there. But I think my best estimate of why the court did this is because the court didn't want to base the court's ruling for probable cause and for the denial of bail. The court didn't want to do that, or bond conditions, I should say. The court didn't want to do that and have it overturned because of making a ruling based on irrelevant subject matter. That's my best guess. But that's a little weird. I mean that's not good. And so when Chauncey Holling says Charles Cook has been embezzling $300,000 from multiple trust funds, including the Lisa S. Cook Trust, it also makes me think, just like he is attributing essentially cyber stalking to victim K, when it's actually him who is cyber stalking, I'm wondering if he's attributing embezzlement to Charles Cook when it maybe is him, when maybe it's actually Chauncey himself who's taking money, spending money inappropriately, not in Lisa Cook's best interest, but in Chauncey's best interest. Hence the new car that he drove, his expensive camera equipment, his bed set that, it looked expensive to me, but what do I know? I don't even have a headboard. But, it looked expensive to me. So all I'm guessing is that maybe some of that money came out of the Lisa S. Cook Trust. That's all I'm saying. But again, nothing to do with his attorney. Because remember, we're looking for things that are going to make the court grant Chauncey a new attorney. He says Lisa Jenness is aware of the situation, but has not reported the crime to law enforcement. Who cares? She hasn't reported the crime. Have you reported the crime to law enforcement, Chauncey? Seriously, dude. Who cares if she didn't report the crime to law enforcement? That's not her job. She is, in fact, protecting Charles Cook, founder of Hope Refuge. This guy is just... I can fully understand why Charles Cook got a restraining order against this guy. He is a nutter. That's not a psychological determination. He's just, street vernacular. The kid is not all right. Core Civic has been labeling COVID-19 deaths as non-COVID related fatalities. Well, congratulations. Apparently Chauncey's now a medical doctor who's done autopsies on the deaths that have been happening around him in prison or what have you. And he has come to the factual determination that just bullshit. God. Multiple individuals have died from COVID inside defendant's cell. Multiple individuals have died from COVID inside defendant's cell. I'm going to let that one sink in for a few minutes. And moving on. The pod is routinely on quarantine for outbreaks of COVID-19. Now, if multiple individuals have actually died in your cell from COVID-19, how is it going to help that the pod? What can you add to that? How much more exposure do you think you can generate sympathy out of? Oh, and the pod is routinely on quarantine for outbreaks of COVID-19. Well, you just said people died in your cell from COVID-19. Oh. I wonder if he's counting individual spermatozoa as individuals. You know what I mean? Like each sperm as an individual. And I'm wondering if he's saying died from COVID, meaning died from died from just dying, and defendant's cell means like defendant's colon? Because that would make sense. Multiple sperm have died inside defendant's colon. Because I'll bet you he's getting lub. Love, exciting and new. Core Civic has refused to allow defendant since his arrival at the Florence facility to see a doctor. For what? For what? What do you need to see a doctor about, Chauncey? You haven't said you were sick. You did you say you were sick? Uh-huh. And what does this have to do with your attorney? He has been denied fish oil supplements. Oh, the humanity. The defendant's health continues to decline while in custody of the Marshal Service. And what does this have to do with your attorney? I think he's just upset over the motion to continue. But again, if your attorney needs time to prepare for trial, considering the attorney had about a month, less than a month, I mean, you give your attorney time to prepare for trial. You just do. The defendant submits the following ground for removal and appointment of new counsel. 1, communication. Counsel for defendant is not actively listening to defendant's requirements for this case. Well, these are my requirements. The defense counsel is there to try to get you found not guilty. That's what defendant counsel is there for. Everything else on top of that is just gravy. Defendant's counsel is there to get you found not guilty. That's what defendant's counsel is there for. Your requirements don't mean squat. The defendant continues to languish in jail while no progress is being made on this case. That is true, but if your attorney needs time to prepare, your attorney needs time to prepare. Lisa Jennis has continued to be allowed to misrepresent victim K et al. As victims. In actuality, they are terrorists. The defendant is the true victim. That argument is not going to get you anywhere, Chauncey. You are the defendant. They are the victims. The defendant, having made the court aware of the circumstances and ground, praised the court for relief. So I don't know if Chauncey's aware of this, but if he gets a new attorney, his new attorney is going to have to prepare for trial too. And so as soon as he gets a new attorney, I think they have it set for January. I think it's set for January 7th. So as soon as they appoint new counsel, that new counsel is instantly going to file a motion to continue, because right now it's set for February 2nd. And so you get a new attorney in there. That attorney is going to have 3 weeks to prepare. 3 weeks is not a lot. 3 weeks is not a lot to prepare. Instantly, especially if he has other cases and stuff going on, instantly he's going to file a motion to continue. So, But the one bright spot for Chauncey, if I'm reading this correctly, I love that his attorney misspelled certificate, is Paul, what is his name? I'm sorry. Paul Butis? Paul Butis from Butis Law Offices at 2403 North Lake Pleasant Road. Did you even get that right? North Lake Pleasant Road. Suite 117, 474. 117, 474. Ah, you got it right. Anyway, Mr. Busing, the above-named defendant, Chauncey Hollingberry, has filed, among other things, a request for change of counsel. See Doc 60. As such, undersigned counsel is requesting the court set a hearing to determine counsel. It should be noted this issue has been previously addressed by the court with prior counsel and with current counsel. See Docs 44 and 56. For scheduling purposes, the undersigned is out of state from December, blah, blah, blah. So another thing is that you don't always get a court. Maybe federal court is different. State court, you don't always get a courtroom. They parcel out the criminal cases first, but you're not always guaranteed to have a court on the date that you go into court. So you could get kicked out a day or two. It could take a long time. You know, you've got voir dire, you've got the actual case itself, you've got jury instructions, you know, you've got all sorts of other stuff to do. I'm sure that since he's going to be out of state from December 19th through January 2nd, he had already planned on taking that out. And I'm sure that that did help him when it came to saying, I need 60 days. Anyway, that's just me being a little, I can't always see the positive side of people. Anyway, I hope that was informative and fun. Thanks for watching. Good luck on your motion for new counsel, Chauncey. Have a great day.